Hello there. I wanted to read a letter which I saw today on Twitter, on the accounts of Richard Gill and then thereafter on Dr. Philip Hammond's account on Twitter, or X. And this is a letter written by Professor Michael Hall, or Mike Hall as he's sometimes called, who was the prospective defence witness for Lucy Letby, but was never called by Ben Myers, the defending barrister. So the team never called Professor Mike Hall at all, despite him being there. Professor Mike Hall has written this letter to the British Medical Journal very recently, to the editor. And as Dr. Phil Hammond surmises, he hasn't had a reply as yet. Mike Hall hasn't had a reply as yet, so it may not be published, but that's yet to be seen. But I wanted to read out the letter, and it's with regard to the obvious failure of the... there's a blurring of boundaries between what the judges in the Court of Appeal feel they're qualified to state or to make judgments about in terms of their knowledge, and they're clearly going beyond their remit and their ability to make judgments, as is made clear in this letter by Professor Mike Hall. They're making judgments based on medical evidence that they have no knowledge of, and they're making incorrect judgments clearly. But also the letter goes into the issue of the medical evidence that was brought out by the prosecution, by the main two, well, principally by one main so-called medical expert witness. We're talking about Dewey Evans, of course. But another one is suggested, which I think must be Dr. Bowen. Although they're not named in this letter. But I'll read it anyway. So it's to the editor, British Medical Journal, and the headline in bold is The Lucy Letby Case and Medico-Legal Boundaries. The appeal court judgment handed down on the 2nd of July 2024 relating to the application for leave to appeal the convictions in the trial of R.V. Lucy Letby raises important issues concerning the interface between the legal and medical professions with regard to evaluation of medical and scientific evidence and the regulation of expert witnesses. I was a medical advisor to the defence legal team in the trial, and I saw and heard the presentation of almost all of the medical and scientific evidence in the trial. I also wrote medical reports on all 17 of the cases which formed the basis for the trial. I was not called by Miss Letby and her team to give evidence. So that's obviously, he means the team really. It was a decision made by Ben Myers and co, wasn't it? To illustrate my concerns, there are two issues out of several which I have selected. Number one, the phrase, in quotes, skin discoloration appears 48 times in the 31,000 plus word document. The names Lee and Tanswell appear 25 times. I'm just wondering what document that is. What document would that be? That I'm assuming that's the Evans report, is it? The report by Evans? Or is it Professor Mike Hall's report? I'm assuming it's the report by the prosecutions in terms of so-called medical evidence. Oh no, perhaps it's the appeal court judgment handed. Sorry, I beg your pardon. It's the appeal court judgment handed down. So skin discoloration appears 48 times in the 31,000 plus word document. That's that appeal court judgment. The names Lee and Tanswell appear 25 times. That's the 1989 paper that the prosecution relied on. Those who are familiar with the details of the trial will be aware that some of the babies who were subjects of the trial had skin discoloration, and that a major component of the prosecution case was that the skin discoloration was caused by Lucy Letby injecting air into the baby's veins, leading to, in quotes, air embolism. The main medical evidence cited by the prosecution that air in the circulation can cause skin discoloration was a 1989 paper by Lee and Tanswell, which reviewed 53 published cases of air embolism. Air is in quotes there. The paper described certain, and he goes into sort of sub-points here. The paper described certain types of skin discoloration observed in the babies, including one specific appearance which they reported to be associated with, in quotes, air entering the pulmonary vascular circulation. The babies were all receiving mechanical ventilation, which was pumping high concentrations of oxygen into the baby's lungs. The judges appear to have agreed with two of the prosecution expert witnesses that any form of skin discoloration may be caused by the injection of air, provided that skin discoloration is not the only clinical sign. The judges did not list the other signs, but sudden unexpected collapse seems to be one of them. There are three potential flaws in the logic of the judges. And Professor Mike Hall then goes on to list the three flaws. Number one, the Lee and Tanswell paper, despite its misleading title, did not describe features of air embolism. Right, so it's not talking about air embolism. The gas which was pumped into the baby's circulation was primarily oxygen, because it's talking about what can happen with mechanical ventilation. So it's about primarily oxygen rather than just ordinary air, which obviously has got oxygen in it, but it's got different levels of it, isn't it, than what's being pumped in through this mechanical ventilation, which is a much higher level of oxygen. Point 2, regarding the flaws of the logic of the judges, except for one specific type of skin appearance, the skin discolorations are as likely, and probably more likely, to have been caused by circulatory impairment associated with sudden collapse, rather than the specific effect of air or oxygen, he puts in brackets, in the baby's circulation. It's the fact that there was circulatory collapse there, circulatory impairment, associated with sudden collapse, and that's what Professor Hall's saying is more likely to be the cause of this skin discoloration. Point 3, regarding the flaws, I have found only one paper which describes specific skin changes associated with the accidental injection of air rather than oxygen. See, Lucy Letby was charged with injecting air, wasn't she, rather than oxygen. So this paper that Dr. Hall has found, what does it say? It goes on to say, into a peripheral vein. So, and the changes there were quite different to those described by Lee and Tanswell, and also different to those described in the trial babies. So I'll just go over that bit again. You'll be able to read it from the pictures I put up, but he's saying there, isn't he? So he's only found one paper that talks about the accidental injection of air rather than oxygen. And in those cases, the changes are different, both to the paper that was cited, that the prosecution are relying on, but also different to the description of the skin changes, of the effects on the skin, the blotching, etc., that is described by the witnesses for the prosecution in the trial in relation to the babies on the indictment. He goes on to say here, in that same point, Professor Hall goes on to say, of particular note, the changes were not transient or migratory. Migratory is put in quotes there. Not transient or migratory. I think because those in the trial they were described as appearing here, there, and moving around, and as in migratory. And that was a pivotal feature of the case, alleged by the prosecution and embraced by the judges. They all got onto the same page as to what the nature of these skin discolorations were. But in this paper that Dr. Hall has found, where there is an accidental, and in this case an accidental injection of air rather than oxygen through a mechanical device, and this is meant to be the modus operandi for Lucy Letby attempting to murder and murdering babies, an injection of air rather than oxygen. Sorry, I'll just somebody called then. An injection of, I've lost my place there. So it's basically different in the in this paper. It's different to what the prosecution are saying. I lost my place there a bit because there was a call. Okay, I'll carry on reading. I thought I might start again, but hopefully you'll follow it. And you'll be able to read it, what I'm putting up here. So the judges got on side with the prosecution, even though there's they shouldn't be, and they're certainly not qualified to. The judges aren't qualified to judge these medical matters, really. An experienced medical reviewer would have identified at least the first 2 points, enabling the judges to determine their significance. So in other words, there just simply wasn't one there to back up the actual reality of this, and so the judges have just gone with these foolish and fraudulent so-called expert witnesses for the prosecution. So there's a second point he makes here. It's a bit difficult to follow his numbering scheme here, but there's another point here, number 2. This is about the second issue, so this is point 2, meaning the second issue. The second issue relates to the suitability of the 2 prosecution neonatal expert witnesses to interpret for the court neonatal practice as it was in 2015 to 2016. One of the experts had retired from clinical practice in neonatal intensive care in 2007. Right. Was he ever in neonatal intensive care? He wasn't a neonatologist, was he? He was a paediatrician. Right. I'm not sure. Was he in intensive care? I don't know. We hear that he was a paediatrician. Yes, he was involved in certain neonatal aspects, but he certainly wasn't a neonatologist. And the other in 2009. I'm supposing that's Dr. Bowen. Supposing that's the case. So, Professor Mike Hall goes on to say that is 15 years and 13 years respectively before the start of the trial. In all, 5 judges agreed with each other that the 2 expert witnesses were suitably qualified to give evidence and that it was for the jury to assess the validity of their evidence. But, first, were the judges qualified to make this decision? Second, as no medical expert witnesses were called for the defence, who might have challenged the evidence of the prosecution expert witnesses, how could the jury be expected to assess the validity of the prosecution medical evidence in the absence of any peer comparators? Well, that's a fantastic point, isn't it? Yeah. And that's the problem with the judge, isn't it, as well? They're just saying, well, it's up to you to decide whether you believe this medical evidence, and they've got no one to compare it with. So it's as much as saying, well, who are you going to go with? Either nobody appearing or the side that's got all these so-called experts who are all on the same page with the prosecution and all backing each other up and all backing up these concepts, 6 of them, as well as the evidence given by the consultants and the police and etc., etc. So it's just completely unbalanced, isn't it? And and obviously the very important point here that Professor Hall is making, that the judges are not qualified to make a decision as to whether those 2 prosecution experts are suitable, because they've been out of the game, as it were, for, as he says, 15 years and 13 years respectively. The last little bit here is just finishing it off. The last little bit of the letter is, there is a need to explore how we, the medical and legal professions, can do better in combining our areas of expertise in the identification and evaluation of medical evidence, and in coming to decisions about where that evidence takes us. In the meantime, we need to recognise and respect the boundaries of our different areas of expertise. So he's clearly saying there that the judges in the Court of Appeal have gone way beyond their boundaries and have simply just denied leave to appeal by sticking with what the prosecution expert witnesses have said completely uncritically, despite Shu Lee appearing there and saying that the prosecution expert witness, Evans, so-called expert, has really kind of abused the nature of his paper and has done these diagnoses by means of exclusion when he shouldn't have done that. And then Evans has got the brass nerve to say that Shu Lee he understands Shu Lee's paper better than Shu Lee does himself, who wrote it. It's just bizarre, and I don't know. Hopefully, this letter will be published in the BMJ. What would be the reason to not publish it? That's a further interesting question, isn't it? Are they trying to block it? Are they being lent on? Is the editor being lent on? Or will they make the excuse? Or is it legitimate? But I don't know. Or will it be an excuse that they'll say, "Oh, we've heard there's a further potential second wave of charges coming," as was suggested in the Private Eye article. I think by Breary. Whether that's going to come or not, is that a kind of an out for the BMJ to say, "Oh, we've heard that the investigations are ongoing, so we can't publish this letter." Although why not? I don't see there's anything wrong with it. And so it's signed off, Dr. Michael Hall, visiting professor in neonatal medicine, School of Health Sciences, University of Southampton, July 2024. So very recent, just last month. And then he cites the 2 papers, the Lee and Tanswell paper, and the other one he found. Willis J. Duncan, Gottchalk, and paraplegia due to peripheral venous air embolus in a neonate, a case report from 1981. So that's the other paper that he found, which was talking about the accidental intrusion of air rather than oxygen into a vein. And the effects of that in terms of the skin discoloration, which was found to be different to both the Lee and Tanswell paper, but also crucially different to the evidence given by the prosecution expert witnesses. So I'll leave it there. So it's a very powerful letter. It should be published, of course. And as Dr. Phil Hammond said, it's very important, even if it's not published, for it to be made public by other means. And this is what I'm doing as well in terms of doing this YouTube video about it. It was made public by Dr. Phil Hammond and also repeated by Dr. Gill on Twitter. So I thought it's fair game for me to then add to it and then just read it out here on this YouTube video. So I'll leave that there. And there's just this side issue now, but it's a huge issue as well, that David Davis, in light of the discovery or the revelation in the most recent trial this year in June, that the door swipe data that the CPS had collated via the police investigation was wrong with regard to this door. In other words, that the timings that were given were actually people coming in rather than, as the prosecution CPS case was stating, that they were leaving at these times. Because in these hospital settings, the usual case is that you swipe to get in, and that creates the door swipe data. You don't swipe to get out, you swipe to get in. And David Davis has written to a member of the CPS, somebody high up in the CPS of that specific area related to Chester. I can't remember her name, but he's written to this person for an assurance or for details with regard to all the other charges on the indictment last year that went through the trial, where all the other timings were crucial to the prosecution's evidence as to how that were they correct, and if they weren't, to what degree, what would the difference be then, to be explicit about it. We've heard already that the CPS haven't stated explicitly whether the door swipe data that was used in the trial in relation to all the other babies on the indictment, whether that was correct. They haven't confirmed it. They haven't said it isn't correct or it is correct. They've obviously got a massive problem on their hands now related to that so-called evidence, which was clearly wrong. Was it wrong on purpose to make it fit? Or was it just wrong by happenstance, by incompetence? But the fact that they made it fit with the wrong evidence, it's certainly in the most recent trial, is interesting, isn't it? In other words, because it made it fit to ensure that Lucy Letby, in terms of the prosecution's case, to put her on her own in certain situations so they could build this case about the fact that this is when the attack occurred, because she's on her own here. But if it's based on false data from the door swipe, because they've got it the wrong way around, you create the data when you come in rather than leaving, then it could have implications for X number of other babies on the cases on that indictment, And how many? The CPS have been cagey at the moment. They're not saying whether the information related to the other babies to do with the door swipe data is correct in the previous trial or not. They've got a lot to work through, and the ramifications of it not being correct, i.e. all the times are all up the spout, is huge potentially. And that's why David Davis has asked for a report on this from this officer or executive or whatever you'd call them, high up in the CPS, whatever their title is, in the Chester region, because that's where it would be located, in the Chester area. So I'll leave it there, and thanks very much for listening. So I think there's new developments all the time, and it's going to carry on in that vein. Sorry about the break and the interruption where there was a call came through which I had to not take, but I'll hopefully that was understandable. But obviously you'll have seen the letter itself in the images that you've seen throughout this video, and you can read it at your leisure and read it over and consider the potential issues that it raises. Well, the actual issues that it raises very, very powerfully. I think we're seeing the prosecution's case fall apart now, subsequent to the convictions. We're seeing it fall apart in real time, as the phrase goes, day on day, week on week, we're seeing every element of it fall apart, aren't we? And indeed the elements of the criminal justice system and how it fails in terms of what Professor Hall is strongly pointing out here, that judges are going beyond they're extending beyond their boundaries, really, in terms of what they're able to and qualified to make decisions about in terms of medical evidence, and that's got very serious ramifications as well. So thank you for listening, and all the best. Have a good weekend. Bye-bye.